The right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013. Rehabilitation and Resettlement Award. Section 31. Rehabilitation and Resettlement Award for affected families by collector. 1. The collector shall pass rehabilitation and resettlement awards for each affected family in terms of the entitlements provided in the second schedule. 2. The Rehabilitation and Resettlement Award shall include all of the following, namely: A. Rehabilitation and resettlement amount payable to the family. B. Bank account number of the person to which the Rehabilitation and Resettlement Award amount is to be transferred. C. Particulars of house site and house to be allotted, in case of displaced families. D. Particulars of land allotted to the displaced families. E. Particulars of one-time subsistence allowance and transportation allowance in case of displaced families. F. Particulars of payment for cattle shed and petty shops. G. Particulars of one-time amount to artisans and small traders. H. Details of mandatory employment to be provided to the members of the affected families. I. Particulars of any fishing rights that may be involved. J. Particulars of annuity and other entitlements to be provided. K. Particulars of special provisions for the scheduled castes and the scheduled tribes to be provided. Provided that in case any of the matters specified under clauses A to K are not applicable to any affected family, the same shall be indicated as not applicable. Provided further that the appropriate government may, by notification, increase the rate of rehabilitation and resettlement amount payable to the affected families, taking into account the rise in the price index. Section 32. Provision of infrastructural amenities in resettlement area. In every resettlement area is defined under this Act. The collector shall ensure the provision of all infrastructural facilities and basic minimum amenities specified in the third schedule. Section 33. Corrections to awards by collector. 1. The collector may at any time, but not later than 6 months from the date of award where he has been required under the provisions of this Act to make a reference to the authority under Section 64. Before the making of such reference, by order, correct any clerical or arithmetical mistakes in either of the awards or errors arising therein either on his own motion or on the application of any person interested or local authority. Provided that no correction which is likely to affect prejudicially any person shall be made unless such person has been given a reasonable opportunity of making representation in the matter. 2. The collector shall give immediate notice of any correction made in the award so corrected to all the persons interested. 3. Where any excess amount is proved to have been paid to any person as a result of the correction made under subsection 1, the excess amount so paid shall be liable to be refunded, and in the case of any default or refusal to pay, the same may be recovered, as prescribed by the appropriate government. Section 34. Adjournment of inquiry. The collector may, for any cause he thinks fit, from time to time adjourn the inquiry to a day to be fixed by him. Section 35. Power to summon and enforce attendance of witnesses and production of documents, for the purpose of inquiries under this Act. The collector shall have powers to summon and enforce the attendance of witnesses, including the parties interested of any of them, and to compel the production of documents by the same means, and so far as may be in the same manner as is provided in the case of a civil court under the Code of Civil Procedure, 1908. Section 36. Power to call for records. etc. The appropriate government may at any time before the award is made by the collector under Section 30 call for any record of any proceedings whether by way of inquiry or otherwise for the purpose of satisfying itself as to the legality or propriety of any findings or order passed or as to the regularity of such proceedings, and may pass such order or issue such direction in relation thereto as it may think fit. Provided that the appropriate government shall not pass or issue any order or direction prejudicial to any person without affording such person a reasonable opportunity of being heard. Section 37. Awards of collector when to be final. 1. The awards shall be filed in the collector's office and shall, except as hereinafter provided, be final and conclusive evidence, as between the collector and the persons interested, whether they have respectively appeared before the collector or not, of the true area and market value of the land and the assets attached thereto. solitium so determined in the apportionment of the compensation among the persons interested. 2. The collector shall give immediate notice of his awards to such of the persons interested who are not present personally or through their representatives when the awards are made. 3. The collector shall keep open to the public and display a summary of the entire proceedings undertaken in a case of acquisition of land, including the amount of compensation awarded to each individual along with details of the land finally acquired under this Act on the website created for this purpose. Section 38. Power to take possession of land to be acquired. 1. The collector shall take possession of land after ensuring that full payment of compensation as well as rehabilitation and resettlement entitlements are paid or tendered to the entitled persons within a period of 3 months for the compensation and a period of 6 months for the monetary part of rehabilitation and resettlement entitlements listed in the second schedule commencing from the date of the award made under Section 30. Provided that the components of the rehabilitation and resettlement package in the second and third schedules that relate to infrastructural entitlements shall be provided within a period of 18 months from the date of the award. Provided further that in case of acquisition of land for irrigation or hydel project, being a public purpose, the rehabilitation and resettlement shall be completed 6 months prior to submergence of the lands acquired. 2. The collector shall be responsible for ensuring that the rehabilitation and resettlement process is completed in all its aspects before displacing the affected families. Section 39. Additional compensation in case of multiple displacements. The collector shall, as far as possible, not displace any family which has already been displaced by the appropriate government for the purpose of acquisition under the provisions of this Act, and if so displaced, shall pay an additional compensation equivalent to that of the compensation determined under this Act for the second or successive displacements. Section 40. Special powers in case of urgency to acquire land in certain cases. 1. In cases of urgency, whenever the appropriate government so directs, the collector, though no such award has been made, may on the expiration of 30 days from the publication of the notice mentioned in Section 21, take possession of any land needed for a public purpose, and such land shall thereupon vest absolutely in the government, free from all encumbrances. 2. The powers of the appropriate government under subsection 1 shall be restricted to the minimum area required for the defense of India or national security or for any emergencies arising out of natural calamities or any other emergency with the approval of Parliament. Provided that the collector shall not take possession of any building or part of a building under this subsection without giving to the occupier thereof at least 48 hours notice of his intention to do so, or such longer notice as may be reasonably sufficient to enable such occupier to remove his movable property from such building without unnecessary inconvenience. 3. Before taking possession of any land under subsection 1 or subsection 2, the collector shall tender payment of 80% of the compensation for such land as estimated by him to the person interested entitled thereto. 4. In the case of any land to which, in the opinion of the appropriate government, the provisions of subsection 1, subsection 2 or subsection 3 are applicable, the appropriate government may direct that any or all of the provisions of Chapter 2 to Chapter 6 shall not apply, and, if it does so direct, a declaration may be made under Section 19 in respect of the land at any time after the date of the publication of the preliminary notification under subsection 1 of Section 11. 5. An additional compensation of 75% of the total compensation as determined under Section 27 shall be paid by the collector in respect of land and property for acquisition of which proceedings have been initiated under subsection 1 of this section. Provided that no additional compensation will be required to be paid in case the project is one that affects the sovereignty and integrity of India, the security and strategic interests of the state or relations with foreign states. Section 41. Special provisions for scheduled castes and scheduled tribes. 1. As far as possible, no acquisition of land shall be made in the scheduled areas. 2. Where such acquisition does take place, it shall be done only as a demonstrable last resort. 3. In case of acquisition or alienation of any land in the scheduled areas, the prior consent of the concerned Gram Sabha or the panchayats or the autonomous district councils at the appropriate level in scheduled areas under the 5th schedule to the Constitution, as the case may be, shall be obtained, in all cases of land acquisition in such areas, including acquisition in case of urgency, before issue of a notification under this Act, or any other central act or a state act for the time being in force, provided that the consent of the panchayats or the autonomous districts councils shall be obtained in cases where the Gram Sabha does not exist or has not been constituted. 4. In case of a project involving land acquisition on behalf of a requiring body which involves involuntary displacement of the scheduled castes or the scheduled tribes' families, a development plan shall be prepared, in such form as may be prescribed, laying down the details of procedure for settling land rights due but not settled and restoring titles of the scheduled tribes as well as the scheduled castes on the alienated land by undertaking a special drive together with land acquisition. 5. The development plan shall also contain a program for development of alternate fuel, fodder and non-timber forest produce resources on non-forest lands within a period of 5 years, sufficient to meet the requirements of tribal communities as well as the scheduled castes. 6. In case of land being acquired from members of the scheduled castes or the scheduled tribes, at least 1/3 of the compensation amount due shall be paid to the affected families initially as first installment and the rest shall be paid after taking over of the possession of the land. 7. The affected families of the scheduled tribes shall be resettled preferably in the same scheduled area in a compact block so that they can retain their ethnic, linguistic and cultural identity. 8. The resettlement areas predominantly inhabited by the scheduled castes and the scheduled tribes shall get land, to such extent as may be decided by the appropriate government free of cost for community and social gatherings. 9. Any alienation of tribal lands or lands belonging to members of the scheduled castes in disregard of the laws and regulations for the time being in force shall be treated as null and void. And in the case of acquisition of such lands, the rehabilitation and resettlement benefits shall be made available to the original tribal landowners or landowners belonging to the scheduled castes. 10. The affected scheduled tribes, other traditional forest dwellers and the scheduled castes having fishing rights in a river or pond or dam in the affected area shall be given fishing rights in the reservoir area of the irrigation or hydel projects. 11. Where the affected families belonging to the scheduled castes and the scheduled tribes are relocated outside of the district, then they shall be paid an additional 25% rehabilitation and resettlement benefits to which they are entitled in monetary terms along with a one-time entitlement of 50,000 rupees. Section 42. Reservation and other benefits. 1. All benefits, including the reservation benefits available to the scheduled tribes and the scheduled castes in the affected areas shall continue in the resettlement area. 2. Whenever the affected families belonging to the scheduled tribes who are residing in the scheduled areas referred to in the 5th schedule or the tribal areas referred to in the 6th schedule to the Constitution are relocated outside those areas, then all the statutory safeguards, entitlements and benefits being enjoyed by them under this Act shall be extended to the area to which they are resettled regardless of whether the resettlement area is a scheduled area referred to in the said 5th schedule, or a tribal area referred to in the said 6th schedule, or not. 3. Where the community rights have been settled under the provisions of the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act, 2006. The same shall be quantified in monetary amount and be paid to the individual concerned who has been displaced due to the acquisition of land in proportion with his share in such community rights.